Pilots and cabin crew have been raising concerns about atypical employment for several years now, but have often been rebuffed with comments that there is only anecdotal evidence, that we need more data, or that there is little interest. With this report from the University of Gent and some of its very clear conclusions, that has changed, and we must act. Can we trust the study? Yes, with verified responses from more than 10% of the active airline pilots across the EU, it is an incredibly statistically robust study covering the breadth of the aviation industry. The practices used in the piloting sphere give an excellent insight into the situation of even more numerous cabin crew. 40% of young pilots aged 20 to 30 are not directly employed. Half of low-fare or budget airline pilots are not directly employed. And 4 out of 5 pilots who are alleged to be self-employed, we would suggest they are in fact bogus self-employed, work for low-fare airlines. And crucially, and here the study tells us how the situation has a much more malignant effect, half of those self-employed pilots say that they are unable to take unfettered professional safety judgments. But pause for a moment and imagine another profession, a judge. How would you feel if you were in court before a judge, perhaps for a traffic violation in your car or a tax error? Would you be satisfied if you knew he only got paid if he convicted you, not if he didn't? Do you think you would get a fair hearing? How about a surgeon, only paid if he operates, regardless of whether it's safe to do so? Or imagine an MEP, only paid if they cast every vote according to their party's instruction. These same perverse and conflicting incentives apply when these crew have to decide whether to call in sick or unfit to fly, whether they are sufficiently free from fatigue to operate, or whether to file a safety report, even though they are far more likely to be in a situation of dependency with the airline when atypically employed. The problems of atypical employment in aviation are clear. The social, the safety, and the economic problems for fair competition. How can we solve them? There are 4 immediate concepts that will make a world of difference. We need to ban pay-to-fly schemes and 0-hours contracts for key safety workers. This is a perverse incentive for them. And we need a route into the profession that is responsible and provides value. Some form of apprenticeship would seem appropriate. We need to strengthen the principle of home base used throughout the legislation. At the conference following the Gent study, we asked labour inspectors about the number of inspections on aircrew they've performed, and the answer was none. Absolutely 0. With the vague smokescreen created by operators moving home bases at will or using them outside the EU, it's virtually impossible to oversee. We need to give aircrew a home in the EU to derive their rights from, and not a loophole for cowboys. We need to prevent bogus self-employment, and I would argue to cap indirect employment, just as is done in the maintenance sector for safety reasons. We need to prevent these setups and have a default assumption of direct employment unless that can be disproven by clear and stringent criteria. And finally, we need to block flags of convenience. When principal place of business is used to decide how an airline is regulated, we must understand it is a reality of their establishment, not a choice of facade or smokescreen. And finally, we need to revise the visa rules for aircrew so that they apply as they would for other workers. Thank you.
Social dumping arises from the fact that we have a single market for the product or the service and 28 or more different social and labour standards in the member states of the European Union. As the Chief Executive Officer of Ryanair has previously said, Ryanair covers the whole of Europe a bit like a social disease. And as it tries to seek out more markets across Europe, it's experiencing greater and greater fluctuations in its pattern of demand. So the question is, how does the airline cope with that pattern of demand? And it does this by exploiting employment systems which allow it to employ people on precarious short-term contracts. So the Ryanair employment model is to hire pilots through an agency based in the UK, That agency puts pilots in touch with different accountants to set up small enterprises, and those enterprises provide pilot services directly to Ryanair. There is no legal definition of a self-employed person in Ireland. There is a code of practice which gives you an indication of the kind of conditions that would apply to a self-employed person. So, for example, the person will be expected to own their own business. They will be able to offer different prices for the work that they do. They will be able to work for different companies. They will provide their own insurance cover. So there's no legal definition of a self-employed person in Ireland, just a code of practice which indicates the kind of conditions that would apply to a self-employed person. So if we go to, say, a base for Ryanair in somewhere like Spain, here's our young pilot who might be Spanish, he might be from Estonia or any member state in the European Union. He's based in Spain, but he works on an Irish contract through an agency based in the UK. He might fly to a market where Ryanair is trying to expand its business, maybe Bulgaria. So he will be on a self-employed contract where the code of practice, for example, says that he can provide services to different companies. He will provide materials for the job, provide the person's own insurance cover, and be able to control the work that he actually does. If you actually look at the contract that the worker is employed under, he's actually contracted to work directly for Ryanair. The only materials that the pilot provides for the job will be the uniform and the identity card. Ryanair provides all the insurance, and it's Ryanair that decides when and where the pilot will work. So this is clearly a bogus self-employment contract. It clearly doesn't meet the criteria of a self-employed employed person. The contract might say that it's a contract for services. The contract might say that if the pilot cannot supply work, then the pilot will supply a substitute. But this is what we call contractual boilerplate. These are clauses put into contracts to disguise the fact that they are actually a bogus contract. So just ask yourself the question, just one condition. Could the pilot provide a substitute to do the work? So if the pilot is unable to provide the services on a particular day, if the pilot is ill, has other commitments, a self-employed person will be able to supply a substitute. Most Ryanair pilots receive their roster at very short notice. They could only recommend somebody who is qualified to fly the particular type of aircraft that Ryanair uses. And of course that person would have to be in compliance with flight time limitations. So the reality is that it would be extremely difficult, if not impossible, for a pilot to be able to supply a substitute. So one of the key definitions, one of the key criteria of a self-employed person clearly could not be met under this contract of employment. So what happens when Ryanair sets up in countries that have variable or very different social conditions? We're probably all familiar with the Danish model, the model of flexicurity, which we know provides very high social standards, decent jobs. It's based on flexibility in employment. It's based on active labour market policies, and it's based on high levels of social protection. But those come mainly through agreements struck between the social partners, through collective agreements. You don't have those protections through employment law. So when Ryanair sets up a base in Denmark and wants to operate on a non-union basis, which is the company's policy, where do workers receive their security, their protection? Because most of it comes from collectively agreed contracts between unions and employers. So this particular model that Ryanair operates creates big problems in different member states around the European Union. So I think that the Employment and Social Affairs Committee needs to ask the question, is this system of rule shopping socially acceptable? Is it sustainable as a model of employment for recruiting new pilots into the industry? And is it safe? We've already heard from the Cockpit Association about their concerns about safety. And if we are going to regulate the industry, we need to consider regulation at the European level that is consistent with the idea of a European competitive social market economy. We need to consider whether sector-specific regulations are required, given the particular nature and the mobility of capital in the aviation sector. And we need to think about how social standards are enforced in particular countries. Because if you're employing somebody on an Irish contract as a self-employed worker, and that's clearly not consistent with your national code, we clearly need better systems of enforcement at a national level. So I think these are all issues that need to be considered in a European context where we have rule shopping and social dumping.
Also, we should remind ourselves that legitimate outsourcing is something different from bogus subcontracting chains. We should not forget that civil aviation has forms of outsourcing such as wet leasing, which are there and legal, and also, and there you can see the problem starting, often used in bogus subcontracting chains. So you have a problem where between legitimate and bogus subcontracting. We also found that you should beware of what is called the bogus employee. Everybody's always looking at the bogus self-employed person, but let us not forget that we are starting to see situations where you could speak of bogus employees, where, for instance, cabin crew members from third countries are being employed, whereas they have very little social protection, they fall without the legislation that protects them within the EU, etc., etc. There's an urgent need for multidisciplinary cross-border cooperation and information exchange between competent authorities and inspection services. Several competent authorities and inspection services will say that there is no issue. I think the report clearly shows that there is. Another aspect that should not be forgotten is management culture. Some of the management cultures are inconsistent with safety management systems. And one of the clear conclusions of the report is that the regulatory framework is not adapted to present-day business models and practices.
Thank you. I'll try and group some of the questions together slightly. There were a couple of questions about the ILO and their role in this, given that we are in a global industry. And the answer to those questions, I think, is yes, there is a role for the ILO. It would be fantastic to see a convention along the line of the maritime industry, but that will be a slow process. It will need consensus, because that's how the ILO works, from employers, employees and governments. And so far, particularly from the government side, that's been difficult to get hold of. So who has to go first? I think it does have to be Europe. If we can't get our own house in order here on these issues, I don't think it's reasonable to ask others in the global community to do so. We do have a harmonised legislative system, and we do have institutions here that can act if they choose to. How do we do that when, as one of the questioners said, we have an ultra-liberal DG move on the one hand in aviation, and a helpful but perhaps less powerful DG employment on the other hand? And I suppose you just need to look at who's left. We need leadership from the commissioners individually and their staff, because they are able to provide it. And we need leadership and pressure from the European Parliament to push the people who should be accountable public servants in the right direction. And I suppose that's why we're all here. Assuming we can do that, how do we realistically make the EU system better? I would say that we can't change what happens to air crews, how they're used, and we don't necessarily need to. But many of the problems we've discussed, the idea of home base, the problems of where is an airline really established, the problems of bogus self-employment, they all have one common theme, which is that there is an element of choice, not real choice, pretend choice, for an operator as to what the answers to those questions are. They get to say, well, your home base is here. They get to say, our principal place of business is there. They get to say, well, you are self-employed or you're not employed. And it's a completely arbitrary choice. There is a reality on the ground that it would be very easy to assess and simply look at where an employee works from and say, that's your home base. It would be easy to look at where an airline actually has its operations and say, that is your place of business. We're not impeding where you go, but we're not giving you an arbitrary choice over where you say you're going. And we could look at the situation of employment and with a clear set of criteria, determine whether someone is genuinely self-employed or not, instead of leaving the first choice up to somebody in an office in a company who has an interest in the answer being one thing or the other. So if we were to have clear criteria for those things, we could perhaps let businesses do what they liked and allow the law and common sense to make the assessment of the home base, where the businesses are regulated, and the status of employment. Now, if you did that, you would obviously have to add a standard of treatment and a standard of regulation that went with whatever the answer was. So if somebody is going to be shuttled around Europe to multiple bases, they need a certain standard of social protection when that happens, in terms of accommodation, social security and so forth. But if one ties that to a genuine assessment of the home base, or a genuine assessment of their employment case, then whatever the answer is, we have protections and solutions to deal with them. So I think it is solvable. Which I guess leads me on to a point that, again, a couple of questioners made. If we were only going to pick 3 things for the aviation package, or 3 things that we could do, what are the most important? I'm going to cheat a little bit and take one thing out of those 3, because quite rightly several members of the European Parliament here highlighted pay to fly and 0 hours contracts for key safety workers as scandalous, or said they were afraid, and I think perhaps we're looking for some reassurance. And I'm not going to give you any reassurance. This is absolute lunacy in aviation. The fact that it can go on today and tomorrow and next week is absurd. And I simply don't understand why there isn't a clarion call across the board to simply ban those practices. That is how I offer my reassurance. Ban them and make the problem go away. So if we do that, we do need to deal with some form of apprenticeship or mandatory traineeship, as Dirk said, to bridge the gap between training and entering the profession. And setting all that aside, the 3 things, I would take the next 3 on the list of the slide I gave you. We need to deal with the home base rule along the lines I just described. We need to deal with the way that we assess employment status and make it a fair assessment and not a smokescreen. And we need to deal with the problem of flags of convenience, which is mostly around how visa rules for crew who a company wants to keep outside the EU work, and how the country of regulation that at the moment they choose works. If it wasn't a choice, if it was simply a matter of facts on the grounds, that would clear up a lot of the ambiguity between, or that allows an airline to slip between different national authorities that can't manage to oversee them, and allow EASA to take a stronger role as well. So I hope that answers those questions. Thank you.